So my first case study that I chose was Moran versus Selig, which happened in 2006. Some background on the case. So in October 2003, a man named Mike Goldberg, who was a former MLB player, brought to light that himself and other former retired baseball players say that the MLB had violated Title VII by excluding them from medical and supplement income plans devised by the Major League Baseball for former Negro League players. They also filed that there was committed battery by subjecting them to a dangerous regimen, also strange shots and other drugs without their consent. And some background on the background. After Jackie Robinson broke the barrier for Negro League players to play professional baseball, having lost their economic base, the former Negro Leagues were not able to pension any medical benefits to former players. So in the 1990s, looking to make somewhat of amends for its exclusion of African American players before the time of Jackie Robinson, the Major League Baseball volunteered to create a plan that provided medical coverage to any former Negro League players, which is called the Negro League Supplement Income Plan. So what I took away from this case was in August 2003, appellant, which was Moran, filed a complaint with the EEOC charging them in violation of Title VII. The MLB had intentionally and unlawfully excluded them from the Negro League plans because of their race. The EEOC brought them the right to sue letter on August 23rd, 2003, and the appellants brought the suit in federal district court on October 16, 2003, joining in with the Title VII charge of neglect and battery. So the verdict, in response, the defendants filed a motion to dismiss and for a summary judgment on January 30th, 2004. In March 5th, 2004, the district court held a hearing. The appellants withdrew their negligence claims, and after hearing about the Title VII battery claims, the district court did end up granting the defendants' motion for its summary judgment. And this concluded there were no genuine issues that could be proven, and defendants were entitled to judgment as a matter of law. The appellants, after a couple of years, eventually appealed that. So why do we care? As most of us will carry on with this field and become some kind of sport managers or directors, we will need to know that racism happens every day. We as sport managers need to know the necessary steps to try and eliminate these type of cases and to make the world a better place. We can closely monitor those around us and simply not take any type of racism or negligence with ease. Make sure there's always a plan for every type of possible situation like these. That is it. For my second case study, it was Jensen versus the city of Pontiac, and this happened in 1982. So a little background. On December 9th, 1979, Jensen attended a professional football game at the Silverdome. Before passing through the entrance of the stadium, she was stopped by a security guard. He asked her to open her purse. She did, and he proceeded to check her purse. All the parties agreed that after this procedure, the guard never touched the woman, and the check lasted all of about 20 seconds. Background on the procedure. For purposes of this lawsuit, all parties must agree on search method before any guard continues. Search method was implemented in 1976 and is still in effect in Silverdome to this day. The main purpose for this search is to protect patrons and performers at any stadium or facility. Secondly, to comply with the Michigan Liquor Control Commission rule. All guards are stationed at exits and inside the stadium. Any person with an oversized item or container is approached by a guard. The guards do not touch the person or property at any time. And person is asked permission by the guard to visually inspect items, but they may also refuse at any time, but may also have to disperse of the item. What I took away from this case, so in this case, Jensen, the woman, was not complaining on how the guard did their job or treated her during the procedure. It was the procedure itself that she was complaining about. The trial court found the warrantless search procedure constitutional, and the plaintiff claims her right to privacy has been violated by the search. The court must determine what is reasonable expectation of privacy under the circumstances. So the verdict kind of concluded that the procedure is constitutional as applied to professional football games. And why do we care? So as future sport managers and directors, this case specifically may happen all the time. If we know our staff is properly doing their job and following the appropriate steps to ensure the safety of others, then there is nothing else we could possibly do. And closely how our staff treats the guests entering stadiums or facilities and making sure no inappropriate gestures are being done and they are following all protocol and procedures is how we can move forward in the future. Sam?